In February 1994, the United States government adopted a regulation mandating specific standards for the quality of the gasoline sold in the United States. The aim was to protect the environment. Oil-producing countries, in particular Venezuela and Brazil, protested. They said that this regulation was unfair. The case was critically important for Venezuela.
Two-thirds of Venezuela's gasoline exports were concentrated on the US market.
The case created tension and controversy. It drew in the industry, trade specialists and environmentalists.
The political context was rather harsh.
The solution was not an easy one, but at the end almost everyone was satisfied. The case was resolved in the World Trade Organization, the WTO. This film looks at how potentially damaging trade quarrels can end in harmony in the WTO. Confidence and trust are essential to human relationships. Societies and civilization are built in them. In international trade, too, confidence is the key. Confidence in what is negotiated, agreed, and signed. Governments have created in the World Trade Organization rules to govern international trade. Those rules have been ratified by members' parliaments which represent their people. But sometimes disputes arise over the implementation or the interpretation of the rules. This is not just quibbling over legalities. Economic prosperity, including people's jobs, are at stake. If governments can't solve their disputes on their own, they come to the WTO, which has a unique system to help them settle their differences.
Now those disputes are not based on power relation, but are rule-based, and this is immensely different.
The dispute settlement is an essential pillar of the WTO. It is a means for conciliation rather than just making judgments. Several recent high-profile cases have underscored the increasingly complex and politically charged nature of trade disputes. In 1994, the Uruguay round, one of the most ambitious international trade negotiations, came to an end. One of its achievements was to create a more effective means of settling trade quarrels.
During the Uruguay round, the dispute settlement system was improved very substantially. It was given a high degree of automaticity, which it did not have before. And we all know that justice not only must be right, but it must also be prompt.
The Uruguay round also led to international rules in new areas, such as trade in services and protection of intellectual property rights. Old disciplines were reinforced and markets further opened up. The success of these negotiations led to the creation of the World Trade Organization in 1995. It replaced the GATT.
Many countries had said, we will agree to open up our markets further. Yes, we're quite prepared to do that, and we want other people to do the same, but only on condition that there was an effective body set up with an effective dispute settlement mechanism. I think we have that now in the WTO.
Disputes in the WTO are among governments. When a member government believes that another has violated WTO trade rules or has acted in a way that deprives business of their trading benefits, it can lodge a complaint with the WTO. The case is handled by the Dispute Settlement Body, commonly known as the DSB, which consists of high-level representatives of all WTO member governments. The parties to a dispute first consult with each other to seek a solution. If these consultations fail to resolve the dispute within 60 days, the complaining party may request the DSB to appoint a panel of independent experts to examine the case. The examination by the panel results in a ruling set out in the panel report. The parties can appeal the panel's ruling before the appellate body. The DSB adopts the panel report and the appellate body report if the case is appealed. Where a violation of a WTO rule is found, the DSB recommends that the defending party brings its trade measure into conformity with WTO law. If it fails to do so, the DSB can authorize trade sanctions at the request of the complaining party. The WTO dispute settlement system is faster and more effective than the previous GATT system. Faster because it sets rigorous time limits for resolving a dispute. It normally takes 1 year from the time the dispute settlement body receives the complaint up to the ruling of the panel, or 15 months if the case is appealed. This is far less time than it often takes to settle commercial litigation at a national level.
Now what you're saying is that in many cases, the filing of a complaint leads to early settlement and tangible results for countries, for companies, for workers, at an early point without the need to go through full litigation.
The new system is more effective because it is more automatic, with reports adopted unless there is a consensus to the contrary.
The losing party cannot prevent adoption of a panel report. Therefore, the credibility of the system, I must say, has enhanced considerably. The automaticity of the dispute settlement system is something which is in the interest of smaller players in the WTO.
In addition, the new system has more teeth when it comes to enforcing the rulings.
Well, the most significant difference is that there are effective sanctions. In the GATT, if at the end of the day you didn't like the result, you didn't have to abide by it, and nobody could do much about it. Now there's, I believe, a rather sophisticated and subtle system which enforces the results.
The system prohibits governments from taking the law into their own hands and acting unilaterally.
So you would say to the weekend? Our primary objective in the Uruguay round in this specific field was to establish a mechanism under which no unilateral measure is to be permitted as a means of solving trade disputes. And from what we observed in the past several years, I think this provision has been observed in good faith in a majority of the cases.
The first case settled at the World Trade Organization involved a dispute between the United States and several other countries. In February 1994, the United States government adopted a regulation imposing certain conditions on the quality of the gasoline sold in the United States. The aim of this regulation, established by the Environmental Protection Agency, EPA, under the Clean Air Act, was to improve the air quality by reducing pollution caused by gasoline emissions. The regulation set different standards for domestic and imported gasolines. It was challenged before the WTO by Venezuela and later by Brazil.
Una violación del principio de trato nacional del artículo.
There is a violation of the principle of national treatment in Article 3, which says that imported goods, in this case the gasoline, once they are on the domestic market of a member country, in this case the United States, can't receive treatment less favorable than internally produced gasoline. We argued that Venezuelan gasoline, and in general imported gasoline, was being submitted to controls and standards much more rigorous than those imposed on gasoline produced in the United States.
The United States argued that this discrimination was justified under Article 20 of the GATT. This provision says that, under certain conditions, countries can take measures that would be normally outlawed in order to conserve exhaustible natural resources or to protect human, animal, or plant life, or health. One of the major conditions is that these measures should not be protectionism in disguise. Venezuela refuted that argument.
Venezuela was in no way questioning the right of the United States to impose very high environmental standards. But we said that if the United States wanted very clean gasoline, they should have submitted both the domestic and the imported gasolines to the same high standards.
The new regulation put in place by the United States had an important economic impact for Venezuela and for the state-owned gasoline producer Petróleos de Venezuela.
Producing the gasoline requested by the United States was much more expensive for Venezuela than if it could have followed the same specifications as domestic gasoline. In total, for the first 3 years, that represents some $40 million.
The U.S. market was critically important for Venezuela and its export earnings.
Approximately 2/3 of Venezuelan exports are concentrated on the U.S. market. So whatever is happening in that country on the commercial side is critically important for us. When Petróleos de Venezuela understood that the discriminatory aspects of the American gasoline regime would not be modified by the United States, it decided to consult the government to assess the possibility of bringing the case to the WTO. It was worthwhile. The process was initiated, and the permanent mission of Venezuela in Geneva asked for formal consultations with the delegation of the United States. These consultations took place in Washington. They did not achieve a positive result. Venezuela therefore had no recourse but to ask the WTO to establish a panel.
Brazil also complained to the WTO about the discriminatory aspects of the U.S. regulation. The two complaints were heard by a panel appointed in April 1995. The panel consists of 3 independent experts chosen by both sides in a dispute. The United States denied that it was discriminating against imported gasoline. It claimed that clean air is an exhaustible natural resource and that it was therefore justified under Article 20 to take measures to preserve it. It also claimed that its regulation was necessary to protect human health, which is permitted under another Article 20 exception. However, in January 1996, the panel ruled that imported gasoline was indeed discriminated against and that this could not be justified, even under Article 20. A month later, the United States appealed the panel's conclusions. Its appeal was based on the argument that clean air is an exhaustible natural resource.
The government was very concerned about the interpretation that the panel had made of the General Exceptions Clause, Article 20.
Appeals in the WTO are heard by the appellate body. This is a permanent group of 7 persons of recognized authority with demonstrated expertise in law and international trade. It does not look at new evidence, but only at points of law and interpretation of WTO rules by the panel. Within 2 months, the appellate body issued its ruling. It confirmed the panel's decision that the discrimination against imported gasoline was not justified under Article 20, but adopted a broader interpretation of this provision.
The United States was not satisfied with the outcome of the appellate body proceeding in that it was still uncomfortable with the interpretation of Article 20, particularly with respect to future conservation and environmental measures. But I think it's fair to say that the appellate body interpretation of Article 20 was better than what the panel had left. And so in that sense, it was an improvement.
No further recourse was available. The appellate body report and the modified panel report were adopted by the dispute settlement body in May 1996, just over 1 year after the panel was appointed. The complaining countries were satisfied with the outcome and the way the dispute was handled.
La resolución de este caso comprobó que el sistema,
The resolution of this case confirmed that the new dispute settlement system was working in a neutral way, a way in which developing countries could trust.
The European Union had a substantial interest in this case and participated as a third party.
The case became all the more interesting on appeal when it turned out that the appellate body had a slightly different view of the matters on the details of the exception of the GATT to and slightly modified the findings of the panel. But we were very happy with the way the appellate body did that and the firm way in which it grounded its decision in the principles of international law and treaty interpretation.
The case was not over. The United States had to implement the ruling. It had to change its regulation. It discussed with Venezuela and Brazil how long this should take.
So it required regulatory action. In the United States, that meant notice to the public of a proposed new rule, seeking comments, a public hearing if requested, and then the publication of a final ruling. And all that was going to take time. The political context was rather harsh, and yet we were able to negotiate with the various interests involved, the conservation and environmental groups, the EPA itself, and the government authorities that are chiefly involved in the regulation of the environment, and our foreign trading parties.
In the end, the two sides agreed on the timing. The United States implemented the necessary changes to its legislation within 15 months, and the dispute was over. Many disputes resolved at the WTO are settled by going through the full litigation process, but often disputes are resolved earlier in the process.
The real successes continue to come through negotiation, through mutually agreed solutions, and that's exactly as it should be.
Protecting intellectual property and artists' rights are one of the new WTO areas of activity. The TRIPS Agreement, the acronym for the Agreement on the Protection of Trade-Related Intellectual Property Rights, requires governments to provide protection for copyrights, patents, trademarks, and so on, through their national legislation and practice. One of the first disputes arising in this area was about a Japanese law, which did not provide protection for recordings made before 1971.
Barbra Streisand, Elvis Presley, Frank Sinatra, the Rolling Stones, the Beatles, I mean, tremendous amount of hit artists were being manufactured legally in Japan and sold around the world and in the Japanese market in a way that would essentially be considered piracy anywhere else.
The Artists and the Recording Industry Association complained to the US government.
We consulted with them, we collected information. We then decided that this case was worth going after as a matter of policy. Many of the Philharmonic orchestras of Europe, the famous conductors, the performances that you've always heard on record, these were also involved, and these too were not being accorded the proper protection in Japan.
Now, on the basis of the TRIPS provisions, Japan, as any other developed WTO member, was obliged to grant retroactive protection until 1946, and that was the dispute about. We did indicate to the Japanese government that their legislation was in violation of the TRIPS obligations, and therefore we requested them to modify the legislation.
We did not think that the interpretation of the TRIPS agreement was wrong. During the process of a negotiation on TRIPS, there are divergent views on the period of retrospective protection.
The United States requested consultations with Japan in February 1996, and the European Union did so 3 months later. The consultations took place in Geneva. If after 2 months a solution to the dispute had not been found, the United States and the European Union could have asked for a panel to be appointed.
We came to understanding with the United States that without going to this legal debates, we will come to a mature solution.
The countries concerned decided therefore to seek an amicable solution and extended their consultations beyond the 2-month period.
Whether we would win legally or not was not really the issue. Whether the country like Japan, huge economy, where the huge cultural industry exists, and where the huge cultural exports do occur, is it right to have this sort of quarrel over legal dispute? So as a matter of policy, we changed our system.
In December 1996, the Japanese government amended the copyright law and granted 50 years backdated protection to past performances and sound recordings. The United States and the European Union told the dispute settlement body that their dispute with Japan was resolved. The result had a major financial impact on the industry.
We think that the worldwide recording industry was losing about close to $600 million a year in Japan before the problem was fixed. That is losses to those artists and songwriters and musicians who depend on those royalties from those recordings that they will never get back.
Over 100 million euro per year were lost to the European phonogram producers.
Even more was achieved.
That settlement would then benefit not just the EU, not just the US, but any party. In this way also, in many cases, the disputes between the large players in the system produce results which benefit even the small players in the system.
The outcome has been wonderful. It's not just the fact that the problem was fixed in Japan. What's happened is other countries around the world, as they have revised their own copyright laws, looked to that precedent and said, we have to provide a similar level of protection for sound recordings, otherwise we're going to end up at the WTO in a dispute. And so that precedent really has had a tremendous impact on the sale of recordings around the world.
On the whole, the dispute settlement system has been a major success story. The large number of cases and the diversity of participants is a healthy sign that governments are determined to ensure full respect of their rights and obligations. They are showing less inclination to resort to unilateral measures or bilateral deals outside the system. Most of the cases brought to the dispute settlement system relate to products of interest for consumers. Consumers therefore benefit from the resolution of these disputes. Although powerful countries are still the main users of the system, developing countries are increasingly active. India, for example, has been a party in more than 20 cases and a third party in 12 cases.
This has given us, I must say very frankly, a good insight into the working of the system. It has made us understand the commitments we have undertaken very well, because when there is a panel case, we have to study very thoroughly. It has helped us. And we feel it is a good and vibrant system.
However, smaller and poorer developing countries often find it difficult to make use of the dispute settlement system.
Because of the lack of expertise in our countries, if there is a dispute, we have to rely on very expensive European or American law firms, which charge a lot of money.
The WTO Secretariat already provides legal advice and assistance regarding dispute settlement to developing countries. But WTO members are currently discussing other ways to assist these countries more effectively. The very success of the dispute settlement system has brought a heavy workload and a strain on the delegations, who provide most panelists, on the members of the appellate body, and on the WTO Secretariat itself. From 1995, more than 170 cases have been brought to the dispute settlement system. Approximately 2/5 of them have been solved, and another fifth are before a panel of the appellate body. Consultations continue for the rest.
The first challenge is the very rapid increase in the number of the cases which are brought to the dispute settlement system. And the second challenge is how to cope with the qualitative expansion of the cases. The disputed cases which are brought to the WTO dispute settlement system are getting more and more complex in nature.
The most complex and controversial disputes are about the protection of the environment and people's health and livelihoods, as well as development and preferential regional policies. Several have hit the headlines. One involves banana imports. Another involves a ban on beef produced with hormones. Yet another deals with the protection of sea turtles endangered by fishing for shrimp at sea. They all illustrate the political difficulties that arise when trade interacts with wider issues. In some of these cases, finding a solution has proved difficult. The system has been criticized by non-governmental organizations which want to present their views before the panels and the appellate body when issues of interest to them are discussed.
Having a diversity of viewpoints and multiple perspectives really strengthens the decision process and allows whatever outcome is achieved to be more serious, to be more authoritative.
But many WTO members are concerned at the possibility of having NGOs directly involved in the proceedings. They argue that the WTO is an intergovernmental organization. Governments are responsible for the commitments they have taken, and by nature the dispute settlement system combines both legal and diplomatic elements.
Panel will have an impossible task if thousands of NGOs all over the world make submissions to them. Therefore, our view is the existing provisions strike the right balance. They give the appropriate authority to the panel to seek outside experts' opinion if they so desire.
Will the dispute settlement system continue to evolve?
There have been complaints by various groups in the world that this system is too secret still, so there needs to be more transparency, more openness, and I think those complaints are founded myself. I think the system can be more open, although it is very much more open than the previous GATT.
The public receives the reports at the same time as WTO members, not party to the dispute. But the rules for settling disputes provide that parties can, if they wish, disclose at an earlier stage their own arguments to other WTO members not involved in the dispute and to the public.
It would be good to get better knowledge during the formation of an opinion why the panel is moving into a certain direction and why they are developing certain ideas.
I do not seriously think that there is any lack of transparency. Panel proceedings and appellate body by their very nature are confidential.
For some, transparency is a real issue.
We are inviting all members of the WTO to open up the WTO hearing process so the public can attend. and the WTO proceedings will no longer be a mystery, and also to encourage and indeed require that all countries make their panel submissions public. So we see an effective dispute settlement system, and a transparent dispute settlement system is very critical to gaining broader public support for the WTO itself.
WTO members are currently reviewing the overall operation of the dispute settlement system, including the transparency issue. The WTO has faced many challenges and played a central role in the successful resolution of many trade disputes. The dispute settlement system will continue to evolve. Good faith, dialogue, and consensus will remain the essence for resolving disputes, and the WTO system will continue to embody these values.